Yeah, so let's get into this. You wrote a piece on this whole topic and on these new laws that have now gone into effect. These aren't theoretical anymore. They haven't been blocked yet by any courts. They are in effect in San Jose and New Jersey. Although I believe the New Jersey one is that in effect right now, or is it there's still
their entire bill maybe stayed, if I'm remembering correctly, because that it was part of a broader bill that did other things.
Some of the restrictions have been blocked by a temporary restraining order from a judge, but those were the sensitive places restrictions on where you can carry a gun. The insurance requirement was not part of that lawsuit. There's other lawsuits going through now. But do you know if they, off the top of my head, I'm not sure if what the effective date of that insurance requirement was.
I think it was January 1st. Okay. So it would have been in effect as of 2 weeks ago. Yep.
So you have to buy some sort of carry insurance. Now, let's get into some of these details because there's going to be a lot of confusion around a lot of these terms because both from gun owners and from people who aren't gun owners because, for instance, the New Jersey one, people in the gun world know of a product that is referred to as concealed carry insurance. But that's not what's being required by New Jersey, correct?
Correct. Yes. So to start, we should say what is actually being required by New Jersey is something of an open question because the statutory text is really sloppy and does not define its terms very clearly at all. So the first question is whether or not this is limited to the requirement to purchase insurance is limited to people with concealed carry permits. The text doesn't say that. The bill was passed in response to the Bruin decision, and the Bruin decision made clear that New Jersey's existing concealed carry permit regime couldn't last because it was very much like New York's, which was explicitly struck down. So the first part of the bill does repeal the existing demonstrated need test, and the insurance requirement doesn't say specifically that it applies to permit holders. It applies to any damage or injury that results from the public carrying of a weapon, of a firearm. So does that mean even if all you're doing is transporting from, a gun shop to your home, is that carrying in that context? If something happened in that period, would you still need to be insured? That's open to question. Also, because it says for any injury or accident, any damage whatsoever, that would seem to say that you would need to be insured for intentional acts. Purposeful use of firearms to either injure a person, kill a person, or damage property. And that is not covered by any insurance products.
So they're trying to require insurance against you murdering someone, effectively.
Basically, yeah. I mean, what's ironic about these requirements is that just a few years ago, we actually saw the exact opposite, sometimes from the same people who've been proposing these requirements, which was when the NRA worked with a broker called Lockton and various underwriters, but most of them were Chubb underwriters, to offer its Carry Guard program. Carry Guard, among the things that Carry Guard covered were defense costs. If you say you believed you used your weapon and you were carrying it lawfully and you used it in a lawful self-defense context, you may still face either civil or criminal prosecution that the insurance would respond, that would cover your defense costs. Now,
and that's what most people in the gun world would call concealed carry insurance, although a lot of these different offerings aren't really insurance in the sense that
some of them are membership-based
insurance policy.
Some of them,
a lot of them are like sort of like co-ops for legal representation or almost retainer.
That is in part response to what happened in New York State. where the New York State Financial
Right.
Services Supervisor sued the NRA, also got consent decrees from the broker and the underwriters saying that this insurance was illegal. It covered criminal acts. And by covering criminal acts, it was against public purposes and could not be offered in the state of New York. The state of Washington had similar lawsuits. And New Jersey also targeted the same program. It didn't technically target on those grounds. There were some other more technical grounds about the insurance processes that the broker underwent. There were certain, like, it's more boring than your audience cares about, but they violated other insurance laws, and it seems clear that they did violate those insurance laws. But what was the goal of this was to take down the NRA, right? It wasn't really whether or not this was a violation of insurance law or not. It was to get a political win from the NRA.
But the point is that insofar as a policy has ever existed to cover you while carrying a firearm in public, is actually these jurisdictions, New Jersey, New York, and elsewhere, that outlawed them effectively, or went
more or less
got them removed from their states. And now it seems like they're trying to require even more so. Like Carry Guard and the others. If you lose those cases, they don't pay for the damages.
Correct.
That was just to pay for your legal representation.
A lot of what has happened since the Carry Guard lawsuits is, as you say, there are more of these cooperative groups that have come together, firearms owners who they're offering a product that they don't believe to be insurance. Some insurance regulators do believe it's insurance, and so you'll have those disputes. And so that they are not regulated by the same rules, and so therefore to keep the insurance regulators away from what they're trying to offer. But yeah, there's great irony there that you would require something that you had just wanted to ban. Or maybe it's not an irony. Maybe that's the purpose, is that we are going to require you to get something that you cannot possibly get.